Ladies and gentlemen of the jury, this is an action brought by Amelia Schroeder as special administratrix of the estate of Felix J. Schroeder, deceased, against the city of Rogers, a municipal corporation, county, as defendant. The plaintiff seeks by this action to recover damages for the death of said Felix J. Schroeder, which she claims was caused by the negligence or wrongful acts and omissions on the part of the defendant. The plaintiff in this action, as the administratrix of the estate of the deceased, is the personal representative of the decedent under the law, and she brings this action for the benefit of herself and two minor children whose names and ages are shown by the evidence herein. It appears in this case without dispute that the plaintiff's husband was employed by the Crane Elevator Company at Rogers and had been so continuously employed for about 10 months immediately prior to the accident here in question, that he had worked both inside and outside of the elevator doing odd jobs and whatever was required of him. However, he had never done any work around the 2300 volt motor in the engine room, but he did know that electric wire circuits entered the building and that one of these circuits came over the cross arm where the accident occurred. In the afternoon of May 9th, 1959, between 5:30 and 6 o'clock, he was painting the south wall of the elevator above what is called the car shed, which has a sloping roof with a pitch of about 3 feet and 3 inches to every 37 inches. Just before the accident, he had come off of the scaffold used in painting the building and had gone to the west end of the roof to notify workmen on the west side. While on the west side of the shed roof, he grabbed with his right hand or came in contact with a brace leading from the electric cross arm to the elevator, and with his left hand he either grabbed or came in contact with a 2300 volt wire near the cross arm, as a result of which he was electrocuted and died in a very short time thereafter. At or about the point where the left hand came in contact with the wire, there was a copper clamp connecting the main wire with the wire leading into the elevator. These wires were insulated with what is called weatherproofing, and where the union was made, the clamp and wires were covered with friction tape. But I think it is admitted that at the time of the accident there was a bare spot on the clamp where there was no insulation. There was a burn on one of the fingers of the decedent's left hand. There is no dispute about the fact that the city of Rogers was, at the time of the accident, operating a power plant in that city for profit. The plaintiff, in substance, claims that the defendant was negligent in placing the cross arm within feet of the roof of the shed when it should have been at least 8 feet above such roof. That is, out of the reach of a person on the roof. That the defendant was also negligent in failing to properly insulate an electric wire within reach from said roof, or where persons working on said roof were likely to come in contact with such wires, that the plaintiff's decedent was rightfully in close proximity to the wires just before the accident, and that these acts of negligence on the part of the defendant were the sole cause of the accident. The accident, on the other hand, denies that it was negligent and claims that the construction was in the usual form and type in such cases. Defendant further claims that the plaintiff's decedent was himself negligent and that his negligence caused or contributed to cause the accident, that he knew of these wires and the amount of voltage provided, that he knew the wire in question carried 2300 volts, and that therewith it was deadly, that he deliberately came in contact with the wire in question, and that the negligence on the part of the proximate cause of his death showed that he had often been warned of the danger of these electric wires and that he willfully disregarded such warnings. So the issue in this case presents questions of negligence, questions of fact for the jury to determine. Under our method of determining lawsuits, it is the duty of the court to pass upon and determine all questions of law, and it is the duty and privilege of the jury to decide all questions of fact, those questions of fact that are submitted to the jury for determination. When those negligence actions were caused, the accident was itself caused by the negligence of the plaintiff's decedent, Felix J. Schroeder. Or was it caused by the negligence of the defendant, the city of Rogers? Or was it caused by the negligence of both of them?